Hello, everyone. Are you able to see the screen all right?
Yep.
Awesome. So my name is Nicolas Sawyer, and today the presentation is going to be about using technology to decrease the amount of time that it takes to appoint counsel. And specifically, we're going to be talking about a project that was implemented in a 5-county region in far west Texas. It's about twice the size of Maryland geographically. And with us today, we'll have 3 speakers. Lori Holguin, she's a court coordinator for the 394th District Court. Paul Chambers, he's the Assistant Chief of the Far West Texas Regional Public Defender. And myself, I'm a policy analyst for the Texas Indigent Defense Commission. Today, we're going to cover 3 major components. Lori is going to be presenting about the user experience of this technology. Paul Chambers will be talking about the benefits and cost savings. And I'll be talking about software and data. So without further ado, we'll jump right in. So Lori, that's it to you. Oh wait, let me see. You're muted.
Hello, I'm Lori Holguin. I'm the court coordinator for the 394th Judicial District Court. And I was able to work with Nick and Paul on creating this, my little user experience end of our new project. So I'll just give a little background of what we used to do before they came up with this idea. So most things were paper. We were still using fax in some counties, which is kind of crazy. And also snail mail. So me as the court coordinator, I also work as the Indigent Defense Coordinator for our court. And so it was my job to gather and process and get before the judge all the applications for court-appointed counsel for our 5-county district. That included, you know, checking fax machines, checking the mail, asking clerks, going to jails, making sure that we gathered from all these different sources everybody's request for court-appointed counsel. Then we would get that, review the documents. Usually they were missing important information that would help the judge determine if someone's indigent or not indigent. And so we'd have to kick it back to, you know, the individual, try to find a phone number for him and ask him to try to fill it out, or call the jail staff. It was just this giant juggling match that we were doing with almost every application. And so we would have to follow up because people wouldn't know how to do it or get back with us. And finally, after a few days, we could finally gather the information that we need to have the judge make a decision as to whether or not the person was indigent and then appoint them counsel. Nick, if you would switch the slide. So we've started using this automation. I think we went live mid to end February, maybe beginning of February. And so we started using this automation during magistration. Mostly, most of the ones we get were from our magistrates. And so if we had, you know, 2 steps to this. There was the original was just to get the data from the application. And so that's where we began, but it turned into needing more information from our magistrates. So we created this magistrate portal, and it gave all the magistrates, because we have about 2 to 3 per of 5 counties, who sometimes magistrate individuals at the jails. And so it gave them one place to fill out this information that we needed, that way we could use the data we collected to check and balance the applications we were receiving. And it helped the magistrates not have to carry the paper and remember to bring it back to their office and have their staff scan or fax or walk it over. And so we're able to get all the data from all the different places, from all the different judges in all the different counties onto one place, and it turned into this check or balance for our information. Next slide. And this is just a snippet of what it looks like. It's a very, very simple fill in the blanks form. It's the front end form is what we're calling it, you know, inter-office, that the magistrate fills out prior to the application for court-appointed counsel. And next slide. So the data from the magistrate's portal is collected and converted into a dashboard interface that I'm able to then look at and compare, you know, everyone who's requested counsel and to the applications that we've received, and it's helped us catch some that we've missed. Next slide. And this is what the collected data looks like. So this is all, nobody sees this but the user, which is me. or the indigent defense coordinator for each of the counties. So all the data comes into an Airtable spreadsheet, and we're able to process it, you know, or sort it or get what we need from it that way. And so that form translates over to this portal. Next slide. Then we go into the main reason we started this was our request for court-appointed counsel. So sometimes people will decline to apply for counsel when they're magistrated. They don't understand, you know, how much an attorney costs to retain, or they think that they won't need it. But once they've had a chance to let it sink in, they may still be in jail, and they'll actually ask to reach out to the jailer or to the jail sergeant and ask them to fill out the form. So instead of, you know, again, doing everything over paper, we've got a little system in each of our jails where they take them to fill out this online form, and they've got mandatory fillable where they can't skip a question. So all the questions that we weren't getting that we had to kick back so that we could capture the correct data, all that's been eliminated. And even so, sometimes later people want to apply a year down the road after they've been arrested and now they've got an indictment or they're actually being charged. They'll realize that they actually do need counsel. So we can also send them to our website or give them this form. They can fill it out on a smartphone or a tablet or a laptop, or they can even come into our office if they're local and fill it out here. And again, it just helps eliminate the human error because they're mandatory fields that they have to fill out. That way the judge can process the proper data and get the form done, you know, without having to kick it back and re-request information and all that. So in every situation where we've used this so far, it seems to have eliminated many, many steps that we were going through before. And access to justice become from what would take days for the back and forth and catching everything and checking the mail to hours. So the human error is gone. The hours spent by the indigent defense coordinator has gone from hours and hours a week to about 5 to 10 minutes a day throughout the day, not all at once. And so it's all done by automation. The only thing that we left was where we can sit down, look at all the data of each of the ones, and the judge makes the decision whether or not these people will be indigent or partially indigent. That way there could be that last little human touch there at the end. Next slide. So all the applications are organized in one place now. That we're not getting paper forms anymore. I haven't seen a paper form in a few months. All the data from those online request forms, they're being captured and translated over to a different, it's another Airtable, but it's a separate Airtable. And that's the Airtable where the judge sits. He can glance at the information, and if it's obvious, he can, you know, make the appointments or deny it. Or you can open it up and actually review each and every bit of the data like we used to back when it was on paper form. So we have that flexibility within the way they created the system. Through that system, that's where the judge makes a decision, appoints or denies, and then a PDF is created and sent out and circulated via email to all the parties that need to have that. And it's all done through automation. There's nothing left for us to do chasing down and making sure we remember to send and stuff like that. Next slide. This is just a screenshot of what the data looks like once it's been captured and moved over to the Airtable. And if you see on the right side, there's different colors. I think they're purple and green and pink. They're on the right side. That's where we put our input in, whether or not the court's going to appoint counsel and which counsel's been appointed. And then that's the information that's used to generate the order that goes out to all the parties that need it. Next slide. And it's like I said, it's taken a tedious task and is a very important task, and it's turned it in from hours and hours a week into a 5 to 10 minute per day. It's very much more efficient. It collects accurate data. It eliminates all the delays that we were experiencing before with waiting for mail or getting, camera pictures emailed to us with dark spots, and it was, it wasn't feasible, and there's no way one person can do all that work. So it's taken something that was just super time consuming and turned it into, like I said, it took us a couple of days to a few days to get an appointment, to now that the attorneys are kind of beating the magistrates over to the jail because our process is down to a few hours. It's greatly improved the access to justice in our district for sure, hands down. And I'll pass it on to Paul or to Nick. No, to Paul.
Yeah, thank you, Lori. So I want to talk a little bit about the impact and cost, not the cost to implement this, but what actually has ended up happening as the cost that we've saved the counties and why this is so important, and the social cost that it saved our clients. In this last year in our 5-county region, we got at the Public Defender's Office, we got almost 500 cases. Each day it cost about $75 for the county to house those people. And so for every day that they spend in jail, that's an extra $75 that the county wouldn't have to spend. We also, all of our counties, they're on the border with Mexico. And so the federal government also pays for beds in our jails for federal cases. And that's about $72.50 or so at a daily rate that they would be paying our counties that are fairly poor to house those people. And then for financial costs for our client, the 6.7 days that it used to take being dropped down to 0.4 days eliminates obviously 6.3 days of incarceration, but that's almost 51 hours of missed work at $7.25. So we're talking about a third of somebody's monthly income if they're indigent that they're missing out on, that they're no longer missing out on. Nick, would you please go to the next slide? And so this is how much we save for each one of those detained people per year, and that's post and pre-implementation. I think the number for this is somewhere in the $235,000 range is what it was costing to house people, and now we're somewhere in the $14,000 range. Next slide, please. So that 94% decrease in cost for county savings, plus the opportunity cost, is somewhere around $343,980. This matters, and I'll tell you why in a minute. We're potentially saving because we would need new staff and an indigent defense coordinator because Ms. Holguin was being a little overwhelmed with the amount of work that she has to do. We almost saved our counties $478,980, and that's about 5/6 of the budget of my office. Next slide, please. So what we found, I think, not with raw data yet because we haven't been operating for long enough, but what we have seen is that we're reducing the time in jail for defendants. It was reducing impact on recidivism and the cyclical impact for earnings, the social impact on children, housing, food. We're also, like Ms. Holguin said, getting faster access to counsel. This obviously increases the likelihood for better outcomes for the client. We're getting cases dismissed, brings us closer to complying with the right to counsel faster. It's decreasing our mental health impacts for our clients. We have a lot of mental health cases out here. The faster intervention means that we can get to those mental health cases much quicker, and we have a social worker that can start working with them faster. And it's less stress on our clients, obviously. They know that someone is on their side much faster. Next slide, please. So the reason why we want to talk about all that money and why the automation is important, I think, and Nick's going to go into this a little bit, is that if you can convince, I know that most of you guys are researchers, if you can convince the places that you're trying to do this to implement some sort of automation, you can take whatever data you need out of that. And you can sell that to the counties by saying that I can save you money. So some of the data that we're collecting now that we didn't have access to before was, we know who's been magistrated in a district and by who. We know who's been in jail or who hasn't been in jail. We know how long it took for that particular person to be magistrated. And that matters for us internally because we can compare outcomes now between clients and magistration. I can check to see if my client, who may be a Black man, got magistrated generally, or all Black people in my counties got magistrated generally slower than someone with, that's white or has, Mexican heritage. And we can use that information to affect like actually substantial change. And we didn't have access to this information before. So those things, I think, when we talk about access to justice, I think this is really a way for the people in this particular call to get data, to sell themselves to places so that they can get the data that they need for their research, and to actually affect like substantial change. And I'll pass it over to Nick.
Thanks, Paul. I appreciate that. So now for the last little 10 minutes or so, I want to talk about the technology and the system and how it was designed and the principles that informed how it was designed, as well as kind of we're going to call for research or point out some opportunities for research that might be available. I was one of the main folks who was responsible for building and designing the system, including developing the connections between all the different software. So the main metrics that were determining whether or not the design of the system was successful pretty much map over what Lori described as the main pain points. So, for example, handwritten requests were difficult to read or inaccurate or incomplete. So that's kind of the first component of the automation, is the intake of the information. Is that data reliable? That's one metric we tried to solve, reducing error. The second problem that helped design the system was reducing the amount of time that it takes to create each of the different documents. So that metric is, does it take less time because it's so labor intensive? And then the third component relates to kind of the final stage of the automation, which is creating and transmitting the documents. And the problem is that there might be inaccuracies in the document. Maybe it doesn't reflect what information went into it. And so making that machine accurate and consistent every time. So those are the main metrics for success in this project. But they weren't the only things that informed the design process, and I hope to get to those in a little bit. So each automation, I think, has three fundamental characteristics. You have the creation or intake of information or data on the front end. And in this case, it's a form that Lori showed earlier that the magistrate fills out when they're taking a request for counsel. And then the second part of an automation is storage and transformation of that information that's brought in. And the final step is transmitting communication of that information or sending it out. And so I'd like to present a little bit of the logic that underlined the background of these three steps. So for the initial request for appointment of counsel, there were some design elements that made it more effective or made it quicker to request counsel. For example, if someone selected, or a magistrate selected that someone was eligible for public benefits, then it would skip some other detailed financial information. And this is because under the law, the Indigent Defense Plan in this area, someone is automatically eligible, presumed eligible, if they're eligible for public benefits. So this is a kind of design technique to maximize completion of the form and the amount of time that it takes. The second way that design is informed, the second part, which is storing and transmitting information, is that there's dynamic documents. Whether the order is finally approved, appointing counsel, or denied, it'll dynamically use different documents. And finally, another example of how state law has informed how this design has come together is under what circumstances Lori is able to issue an order, or the court, the judge, Ferguson, is able to issue an order appointing or denying counsel. And under state law and under this plan, the district court has jurisdiction over felonies, but it would be the judges in each of the counties who would be appointing in misdemeanors. And so in these circumstances, while Lori's system can still appoint for felonies, the system automatically sends the request already automatically filled in, unsigned, to those county officials based on a database of connection of emails in order to speed up their processes. So when Paul was talking about impacts, there are other impacts for other counties in the amount of time it takes for them to process. So those are the three main components of the automation. When it comes to software, I guess we could send these out, send this slide out at the end, or I can put it in the chat. Go ahead and Google and these different software. I'm not going to go over each of them individually, but these are the main softwares that were used for creating this system. And I really want to spend more time on these last two. So in addition to the problems that Lori faced, there were 4 other design principles that I think are very important for automation. And I'm pulling from them from this study, designing automation for human use. And I think this is a study from 2000. It's quite an old study, but it shows that a lot of this technology has existed for a long period of time, but hasn't quite been put into practice yet. So that's kind of an exciting part of this. So finally applying these principles. And I want to cover 4 of them. So the first one is keeping the user in command. So Lori as a user has these different dashboards and interfaces, is able to view all of the submitted information and make edits to it as she goes along. She's able to make edits to the formulas that calculate indigency, update them. If it's a new year with new poverty guidelines, she can insert those new numbers. She is really in control. And that's very helpful and reduces drag if Lori would have to otherwise reach out to a third party. The second design principle from this study that helped inform this process is choosing the right level of automation. And because someone could ask, well, why not automate the whole thing? Why not just have requests go straight into an order that approves or denies based on the calculation and then file it immediately? Well, besides issues with quality control, right? You want to make sure that each request that comes through is real and isn't automatically filed and emailed to county officials. But there are also some restrictions around law. Appointing authority, indigent defense appointing authority under Texas state law is really for judges or their designees. And so the question of, can a computer program be a designee under that statute? I'm not sure, but we don't have to answer that today because really it is the judge that makes the final decision, or the designee. So that's where, in this case, choosing the right level of automation, everything else is automated except the decision to appoint and selecting the attorney. So that's been maximized. Number 3, considering human performance consequences. It's important to build documentation for any system that you build. So for example, if Lori were to move on, she already has that experience of knowing how to create those forms manually. So without the system, if she were to train someone else to replace her and she were to go off and you retire, does that other person have the capability to perform the task manually without the system if the system were to break down? So it's really important that there's documentation for performing the system manually in case the system were to break down. And the final factor that's informed this design is transparency. And in one of the software programs I mentioned, Zapier, that's the automation software. Within it, it's possible to see histories of automations and flows that have run. And you're able to see if there are any errors or issues by logging in and viewing past automations. And so Lori can go into there and see, or any user really can go in there and see what went wrong in case there's some kind of bug, and then take the appropriate steps. So these are the different principles from the study and how they kind of informed this process. And so Paul covered this fairly well in talking about what kinds of data are now available around magistration proceedings, which is these first proceedings in Texas. You have access to a bunch of demographic data about defendants. You have information about the judges. You have case outcomes. You have timelines for appointment, how long it takes to dispose cases, the outcomes of cases. And here are 3 examples of places to start. Case outcomes may change depending on how much someone has had to wait until their appointed counsel. Having early appointment of counsel not only means early intervention, but it also means that in cases where evidence quickly disappears after an arrest or an event, that may change case outcomes, having access to that information. Paul mentioned this as well, case outcomes and bail outcomes actually, yeah, I don't know if you mentioned a presence of counsel at magistration. In Texas, it is a minority of circumstances where when someone is at their initial bail determination that they have counsel. But in a case where a system like this is set up for appointment, that would be an interesting question to explore. And then finally, looking at county cost savings, as Paul went into. As the program continues to run and possibly develops in other county areas, we'll gather more data and we'll be able to kind of take a deeper look at how cost savings come out. But that is it for now. I don't know if we have a time for questions before the next one, Doran. But that concludes our presentation.
Yeah, I think
appreciate you all taking the time.
A couple minutes, but
okay.
I don't.
Well, if we've got a couple minutes, are there any questions? Like we can take a look at the chat.
Yeah, so there is one from Ali.
So I sort of answered that one. I was wrong. I'm sorry. The form that was on the slideshow is actually the magistrate's portal, but it looks the same. And then I think Lori just linked an actual link, like a live link to the request. So
Exactly. It's a live working form, but you can take a peek at it and scroll through it, look at it. If you accidentally get crazy and hit submit, just let me know so we can adjust the data.
And then as far as appointments, I mean, I answered it very briefly, but the long answer is, I think internally at the public defender's office, we were receiving about 2 to 3 appointments a week that would come in waves of about 15 or so every 2 or 3 weeks. We're getting 1.5 appointments a day. I don't know that right now I can attribute that solely to the automation program, but it has gone up substantially since we implemented this.
And there's a question from Larry Jefferson. How are clients that are out of custody notified of their requests? There's a mandatory field. It's not mandatory. There's a field to put in your email, and it lets you know that the email address that you put in there will give you a copy of your form, whether it's denied or approved. And it also lets you know that you've completed the form properly and it's before us. So they get 2 emails from us if they put in their email address.
And is that works similarly for folks that are in custody because they're filling their
mail, their email while they're in custody, but it also goes to the jail that they're in, and so the jail will print it and give it to them.
Ah, so they know before they even walk in.
Correct.
And so that means the court doesn't have to spend time making that determination in court and giving potentially information to the prosecutor about whatever their income level is that could be used prejudicially against them in their case. All right. This is really cool.
I think there was another question about level of security, encryption of data, confidentiality of client info being stored in Airtable. Yeah, it's a complicated question, and I won't spill all the details of the security protocols we have in place, but they are industry standard. They've been reviewed by security professionals. Use things like 2-factor authentication, generally to the level that would could protect client data. Although this isn't necessarily under the attorney-client privilege, because the court, who is appointing counsel, is not the attorney for the client. So there are different rules for keeping that data confidential.
Mr. Chambers,
sorry, go ahead.
Mr. Chambers, has this allowed your attorneys to see people before arraignment? So
yes, in fact, I am one of them that beats people to the jail. It's happened. This is anecdotal. I mean, but I've done it 3 or 4 times, and it's never happened before in the 7 years that I've practiced here. So
I think that's incredible, because if your client knows who you are before arraignment, they have so much more confidence in you about what's going to happen. You can have a plan of action. I want public defenders to know their clients way before arraignment, because then you can have, what if we worked in a world where you get the disposition before arraignment? That'd be amazing, because then it gets off their record so much faster, and you can get a connection to the community.
Well, so in,
workers. Oh my God.
yeah, right. So in Texas, we have a magistration, and that particular thing is where they actually have the first hearing where bond is set. And so if I am there, I can actually advocate in front of that magistrate to get someone out of jail without having to file any documentation. I can just sit there and say, hey, this needs to be whatever kind of bond that my client can make. So it has actually been fairly revolutionary here.
There's a good one for you, Paul. Do you actually have data on the impact of the system on pretrial release rates?
I have initial data, I guess is the best way to say it. We haven't been operating for long enough for the data to be real solid. Effectively, what I'm seeing internally is that we're getting people out of jail on felonies about 15 days faster. So.
That's great.
Do we have time? There's a few more. Do we have time, or do you want to cut us off?
I think we could do like one more. I think that's reasonable.
Okay. Next question is, do you have any problems with Class C misdemeanors? So that's in Texas, fine-only offenses where you, under the law, do not have a right to an attorney. So Lori, have you seen, or Paul, have you seen requests for Class C misdemeanors?
I just saw one today, and we let them know that they didn't qualify. So it's just real easy to catch, and usually the magistrates are helping them on that end anyways. But there's been maybe 2 or 3, and we've been able to catch them all. And if we don't, the fail stop is the attorneys will get it, see the charge, and know right away as well. So.
Okay. Well, thank you very much.